This conference will now be recorded.
I want to welcome everybody to today's meeting of the Judicial Review Committee. Our topic today is agency litigation web pages. But first, I think that we've got some introductory remarks from Matt, and then I've got a few things, a few orders to business I need to mention as well. So Matt, do you want to go ahead?
Well, the only introductory item I have is to, though he's not yet on the phone, is to welcome Albert Lynn, one of our new public members and a member of this committee. Albert has a very distinguished background that I think will serve ACUS very well. He's currently a partner at what used to be Hunt and Williams. I don't know the name of the firm now. He was previously the Solicitor General of West Virginia for a fairly long period of time, I think about 5 years. And before that, among other things, he was a lawyer in the federal programs branch of the civil division at DOJ. So we hopefully will see Albert soon, and we can all welcome him to the committee. That's all I have to say, Kristen.
Great. Before we get started, I just wanted to remind everybody of sort of the basic rules under which we're operating. We do have members of the public who were planning to join us today. So just as a friendly reminder for everyone, ACUS members, their designated alternates, senior fellows, liaison representatives, and special invited guests have full speaking privileges and are able to unmute themselves. To avoid background noise on this virtual format, I would ask that you keep your microphone on mute and either add a comment in the chat or physically wave at me by video if you would like to speak. I'm going to keep a queue and call on those folks, and then that group of people can unmute themselves and then remute themselves when they're done speaking. For members of the public who are with us, please also use the chat feature to indicate if you'd like to speak. I will turn to you at an appropriate point in the meeting, and the ACUS representative running the GoToMeeting platform will unmute you, and then you will be remuted when you are finished speaking. For those members of the public who wish to speak, I would like to ask you to please be aware that our rules generally provide for ACUS members, designated alternates, senior fellows, liaison representatives, and invited guests to take precedence in the speaking order. So I would ask members of the public for their patience when waiting for their turn to speak. But if you will signal in the chat feature that you will like to speak, then after everyone else has had their opportunity, we'll give you an opportunity to do so as well. In the event that we need to take a vote, I don't really anticipate we're going to need to take a vote today, but in the event that we do, please be aware that only members of the Judicial Review Committee have a vote. Members of the Judicial Review Committee includes government members, their designated alternates, if the government member is not present, public members, senior fellows, liaison representatives, and special counsel all have a vote. Please do not vote if you are not a member of the committee. And Mark and I both have lists of committee members in case you are unsure of your status, so you can reach out again via the chat feature to ask if you're unsure of your status. Regarding the chat feature, please refrain from posting substantive comments or questions in the chat area. In our last meeting, we got to a point where we were having people put comments into the chat, and that chat scrolls along pretty quickly, and it's not saved in the GoToMeeting platform, and it's pretty easy to miss things. So we would prefer that you not post substantive comments or questions in the chat feature, and instead just use the chat feature to signal that you have a comment or a question that you wish to share, and then I'll put you in the queue and we'll call on you. We do have a lot to cover today. As you saw undoubtedly by email, we received a lot of comments, including a couple of red line markups. So we have, it's going to be a little bit of a challenge to juggle all of the paperwork, given that several members of this committee have submitted comments. I've got them kind of organized, and we're going to go through them, and I'll talk in a few minutes about the order in which we're going to go through things. But I'd ask also for your patience and cooperation. And if you think we're missing something that we need to be talking about, then by all means, please signal to me that you want a chance to speak. In any event, okay, with that, I am going to turn over the meeting to Mark, who has a discussion of recent changes to the draft recommendations, as well as some other aspects of what's gone on since our last meeting. Mark, you take it away, please.
Thanks, Kristen. So as Kristen mentioned, we have a lot to get through today, so I'm just going to take a couple of minutes to quickly explain a couple of the more significant changes between the latest draft of the recommendations and its predecessor. I'd also like to briefly raise a few topics, most of which were mentioned in one or more of the comments we've received on the draft recommendation that I think the committee might wish to consider today. In terms of the recent changes to the draft recommendation, the most notable are the last two paragraphs of the preamble. At our previous meeting, there was a lot of discussion about the need for agency discretion, both in terms of creating a litigation web page and also in terms of deciding what does and does not appear on it. The last two paragraphs of the current preamble now make clear that agencies have significant latitude in both of those areas. The point, and I think the preamble emphasizes this repeatedly, is that agencies' decisions about creating and maintaining litigation web pages have to be informed by their unique circumstances. What that means in practice is that the recommendations will not function as some kind of inflexible command that agencies create a litigation web page or that they put every single litigation filing on it. Consistent with the draft recommendations, agencies will have enormous flexibility in deciding not just whether to create a litigation web page, also what goes there. So to the extent committee members are worried about this recommendation requiring agencies to publish documents that they have good reasons for not publishing, I would suggest that those worries have largely been addressed. The other change I want to mention regards recommendation 2. You'll see in the draft recommendations that, consistent with suggestions from our previous meeting, we have modified the list of considerations agencies should take into account when deciding whether to create a litigation web page and deciding what to put on the web page. As currently drafted, the list that we have there is not exhaustive, although, and this is just based on some of the comments we've received between the previous meeting and this one, my guess is that people would like to add to that. And those additions are entirely warranted. There may well be other considerations to which we ought to call agencies' attention. That's up to the committee. I think it's important to note that here too, the draft recommendations don't purport to tie agencies' hands in any way. They just say, here's some of the considerations you might want to account for in making these kinds of decisions. That's it. Now I kind of want to switch gears and highlight 3 topics that I imagine the committee might wish to consider this afternoon. First, there's a question about whether the committee ought to limit the recommendations to litigation materials that are filed in or by, in the case of judicial opinions, Article 3 courts. At our last meeting, the committee spent a good deal of time discussing, for example, tax court proceedings, and I think it's at least worth considering whether limiting this recommendation to Article 3 court filings might be advisable. Second, it seems prudent, and this is in keeping with Alan Morrison's comments, to consider whether DOJ merits some special mention in the recommendation. With any recommendation concerning litigation involving the federal government, DOJ is necessarily going to be front and center. It might be worth discussing to what extent DOJ's kind of primary role as the government's lawyer warrants special mention in these recommendations. And then third, and I think finally, I think it might be worth discussing what, if anything, to do about agencies that handle an extraordinarily high number of cases. Maybe there's some reason to single them out in this recommendation, and it might be worth discussing how to do that. Or alternatively, the existing recommendations might be perfectly fine in that regard, again, because they already leave agencies considerable discretion to account for things like caseload. So that too, though, is something that I think ultimately the committee might wish to consider today. Overall, I'll just close by saying that I think the latest version of the draft recommendations is in much better shape than the previous one, and that is pretty much entirely due to all of you and your helpful comments, not just at the last meeting, but in the interim. Particularly to those of you who submitted detailed written comments about the previous version. I just want to tell you that I think all of us appreciate the time you spent working to make the recommendations better. And I am really looking forward to hearing what you all have to say this afternoon. That's it for me.
Great. Thanks so much, Mark. So what I propose that we do is that we're going to start with the individual recommendations themselves and go through them one at a time, addressing the proposed edits and other issues that they raise. After we've dealt with the individual recommendations, then we will turn to the preamble and propose line edits to the preamble. Once we've gone through those, some of the comments that received also just raised separate issues. I anticipate that we're going to be talking about most of those issues in the context of going through the individual recommendations, and as well as the preamble. But in the event that there are still some issues that have been raised that are left over after the fact, I've got at least a little bit of a list of those, and I'm going to try to keep track of them through the discussion, but we'll turn to them last. Again, because we've got a few different markups as well as a few different sets of comments, all of which are excellent and all of which we want to get to, but it's a lot of paper, I would ask for your cooperation for those people who submitted those comments or suggestions. If you think that I'm leaving something out, please do not hesitate to flag me down either in the chat or by waving your arms and say, hey, we need to talk about this, that, or the other. I'm going to run the meeting, but I'm going to ask for your help in doing it. So with no further ado, I guess let's turn to our first recommendation, which starts around line 60 or so. Are we going to pull those up onto the screen, Mark? He's getting there. While Mark's pulling them up, just give me a second. We're going to wait for them to get pulled up to start on that first recommendation, but everybody can turn to that in their own materials as well. So as regards the first recommendation, starting on line 59, so I see Andrew Vollmer in his comments raised a question about on line 60, as well as a couple of places in the preamble, about the use of the term consent decrees in lieu of settlements, and whether we should instead go back. I don't remember if the original had the word settlements in it or not. But he was wondering about whether it's appropriate to use settlements instead of consent decrees here. I don't necessarily have any views on this, but I welcome views from the committee. Alan, please go ahead.
First,
Alan Morrison, Senior Fellow.
many settlements are not filed in court. That's the first thing. Second, as long as everybody understands that's clear, consent decrees would be filed because they're approved by the judge. Kristen, I have another comment, not directly related to that point, but I can wait on making that.
Why don't we deal with this and then we'll come back to you, okay, Alan?
Okay, thanks.
I will note with respect to consent decrees that we do have, it does say publicly filed pleadings, briefs, and consent decrees. I'm frankly ignorant on the point of whether consent decrees are subsumed, are they a subset of settlements? Such that if we use publicly filed settlements on this list, that would include consent decrees?
It would. And maybe we can clear in the preamble.
I'm sorry, say that again, Alan?
If we say, we'll discuss this also in the preamble, and where we say settlements in the preamble, we could put including consent decrees, but we don't have to put that here in the recommendation.
Well, I believe I could be mistaken, but Andrew flagged two places in the preamble that also used consent decrees rather than settlements. I'm not sure that settlements are separately mentioned. Um,
Well,
was this a change from earlier, or is this the way it's always been?
This was a change from earlier. It was made pursuant to some discussion at the last committee meeting. There was the same level of uncertainty about the public or non-public nature of settlements versus consent decrees. I believe, I forget who made this comment, that consent decrees are a species of settlement. For what it's worth, that had been my understanding as well. And so long as it is, as you say, Kristen, limited to publicly filed settlements, that seemed to me to address the problem last time. But the consensus last time seemed to be tilting toward consent decrees. So
I guess I should ask if anyone has any objection, given the fact that the line does include the descriptor publicly filed. Would anyone have any objection to changing consent decrees back to settlement?
So, Kristen, this is Trita Tanuzzi. Can you hear me?
Rita, absolutely. Go
So
ahead,
is the
please.
notion here that instead of a settlement between parties, this is something that has the blessing of the court, so it has a higher level of application? Is that the notion here, that it's court approved? Because often courts just allow the parties to file their settlements, and certainly in tax court, so they don't really interfere or intervene in what the terms are. But does this suggest that the court has blessed the settlement and so has adopted the view or the position?
I don't know. Not having been much of a litigator myself, this is not something in which I have an opinion. Alan?
the many settlements are not filed with the court. Sometimes they have to be, but most of the times they're not. And so I think the publicly filed takes care of the problem. And I would just say public briefs and settlements include. I mean, this says including, so we're not stuck with our thing now. We're not writing a statute here.
Kristen, can I just offer a quibble here, or maybe a question for the committee's consideration? And I had some hand in this consent decree stuff, so we're generally talking here in this recommendation about, filings made by the agencies themselves, as opposed to other litigation materials, including orders and decisions of the court. Like, decisions of the court are not covered by this recommendation. Is that right?
No, they're covered by the next.
They are covered, because the next
They are
line says
covered
as well
by-
as court decisions.
Next phrase.
Oh, I see. All right. I see. I'm sorry. Court decisions. I would strongly, on the particular subject of consent decrees, I think the committee could say, so you could use a term other than consent decrees, like, judicially approved settlements or something, but it has to refer to the actual court doc. It can't just be, we can't, as Alan points out, just talk about settlements, because settlement agreements, by and large, unless they have to be approved by the court, like in a class action, where they're submitted as a proposed consent decree, they're just, as a matter of, they're seldom filed. So I think something needs to be done here. I think settlement does not work.
Okay. John Siegel, I see you have indicated you wanted to speak.
Is something of a quibble, but I just want to point out that if we simply strike consent decrees and insert settlements in lieu thereof, we'll be back, I think, to the ambiguity that we originally had, which is that it's not clear whether the adjective publicly filed applies all the way down to what would then be settlements. So perhaps the solution to all of this would be to have a definition of agency litigation materials, which we have in the first paragraph. I would always have preferred that the definition be in the recommendation, not in the preamble, but wherever it is, I think we agreed at the last meeting that the definition only includes publicly filed materials. If you just make clear somewhere that it's all limited to publicly filed materials, then I think settlements would be okay.
Andrew has a question or comment, but let me throw out a phrasing possibility. We could say agencies' pleadings, briefs, and whether it's settlements or consent decrees that are publicly filed. You know, move publicly filed afterward rather than the beginning of the list, so that it's clear that it applies to all three. I don't know if that helps or not. Andrew Vollmer?
Well, hello, everybody. I think it does not help, Kristen, actually, because
Fine.
I think it creates the same ambiguity, but that's not why I wanted to chime in. The comment is that some settlement agreements are filed. So even if, and that's true even in agency cases, if we are going to limit the recommendation to court file documents, settlements is still the right word. Consent decrees are in fact judicial or court orders. In SEC cases, they're injunctions. So consent decrees to me have a very specialized meaning, and I believe that's true generally in Supreme Court jurisprudence. The question is, why do we want to limit this to only court filed documents? And so I understand we don't want the whole world covered by the recommendation, but settlement agreements that are not filed still are extremely important for the policy reasons that are the premise for the whole recommendation. And so it just finally occurred to me, like, why are we drawing this distinction between significant litigation related material that's filed versus not filed? Is it just administrative convenience because otherwise the world would be too big? So anyway, that's my question.
So this is Drita, and I would say that for the IRS, we would not be able to post anything that was not publicly filed, because then we would run into taxpayer information issues. So we wouldn't be able to. So the fact that it is filed and public is what permits us to then put it on a website.
I don't think anybody's talking about filing or posting anything that isn't publicly filed. I mean, we may need to figure out how to wordsmith this line 60 in order to make clear that all of pleadings, briefs, and whether it's settlement agreements or consent decrees, that all of them are supposed to be things that are publicly filed. But I haven't heard any suggestion of anybody wanting to post things that aren't publicly filed.
Well, that's what my question was.
May I just jump in here? And I
Yes,
have
please.
just two things, and at the risk of entirely contradicting myself based on, but I may be doing that because I heard some comments from John Siegel that I actually found persuasive. If you have the word publicly filed settlement agreements or proposed settlement agreements, something like that, that actually might work. And I actually, this is maybe a further quibble here, but I'm wondering if a party, an agency really files a consent decree, the decree doesn't become the consent agreement doesn't become a decree until the court orders it as such. So you're not really filing a consent decree, you're filing a proposed consent decree. The larger point, though, in response to the other point I want to make in response to Andy, and this is really, I think, a question for Reeve, if I can put you on the spot. There were we have had some discussions within ACUS, within the Office of the Chairman, about doing a separate project at some point on settlements. And I'm wondering, Reeve, if the issue of settlements, and I'm referring to settlements that are not embodied in orders of the court, like consent decrees, whether settlements are sort of outside the scope of the project as the council approved it.
Yeah, so that would be my interpretation as well. I mean, I'd see that as sort of a separate issue. May well be worth taking a look at, and I think probably there's some complexities that would really need to address, as part of that, as to what's in and what's out. But yeah, I would tend to agree with Matt that I would think that if we expand it to include all settlement agreements, that would be sort of beyond what the council had approved here. That we're talking about publicly filed documents, at least for purposes of this recommendation, this project. Though, settlement agreements may well be something that's worth looking at in greater detail as part of a subsequent study.
It's Vollmer. I'm happy to defer to that as well on the theory that let's not bite off more than we can chew and let's just deal with filings in court. That's fine. But I would still support the broader phrase settlements.
Robin Greenhouse? Robin, did you have a comment?
Yes, I did. I was on mute. Sorry.
No problem.
My understanding was that, the idea here was to take the docket sheet in the court and to the extent that the agency wanted to, they would include on their webpage the pleadings that they filed and then the court decision. And then, if the court had, judicially approved an order. And that was sort of the parameters, the box around which, I was thinking through this. And if it's broader than that, I think we need to understand that.
That was more or less my understanding as well. I mean, at least to the extent that that encompasses things that are publicly filed. I don't know what would be publicly filed that wouldn't be on the docket sheet. So I guess, the question comes down then, I'm getting a little bit of a sense that we're heading more toward replacing consent decrees with either settlements or settlement agreements. I'm not sure which.
Kristen, I have a comment on that.
Go ahead.
I think we can do this by breaking the sentence in half. I'm sorry, breaking it into two sentences. Agencies should consider providing access on their website to agency litigation, to publicly filed litigation materials as well as court decisions. Publicly filed litigation materials includes pleadings, briefs, and settlements, period.
Okay, so
That takes care of John Siegel's grammar point, I think.
Publicly filed agency litigation materials. So we don't delete the word agency.
So yeah, just publicly filed as well as, what you have to do is to take we started working. I was just going to take out the including phrase from what you had there and put that at the second sentence. I think that would work.
Yeah, so it would be publicly filed agency litigation materials as well as court decisions bearing on agency's regulatory or enforcement activities. So that latter part of the sentence.
Yeah. And
then we would say agency litigation materials include
whatever you want. Yeah.
Pleadings, briefs, and settlements. Or settlement agreements. Is it settlements or settlement agreements?
I would make it, this is Vollmer, I would make it just settlements because you're not trying to limit it. You're trying to cover documents that in the litigation that's publicly filed.
Okay. I have to take other people's suggestions on this one because I don't really know the difference myself. Does anyone have any objection to settlements instead of consent decrees?
Do we need publicly filed again in that second sentence?
It might be nice to emphasize it, given that a lot of people seem to be confused about it.
Are we losing the meaning here? We have the phrase, maybe I'm misreading what's on the screen. We have the qualifying phrase bearing on agencies' regulatory enforcement activities, which relates and modifies court decisions. Does it also need to relate back to publicly filed litigation materials? I think we've lost the intended meaning here.
If that's the intended meaning, then I think then we would put a comma after decisions. I can see doing that.
It's
Does
just a
anyone
question
have
for the committee.
Does anyone have an objection to doing that? Adding a comma after decisions. Does anyone have an objection to recommendation number 1 as worded on the screen at present? Okay, hearing none. I guess we're ready to. Oh, Alan, go ahead, please. Alan Morrison, are you on mute?
I now am, yeah.
Okay.
This is a general point that others have made, and I also made. But the number of agencies, IRS, the Social Security, and the veterans all point out that they have a very large number of issues, of cases, most of which are not significant from a regulatory perspective. This says should consider, which means that agencies have a discretion. But I think we ought to be more definite and make it clear that routine cases by agencies that they should presume that they don't have to put them up. I haven't got the right words on this now, but I want to get the concept. We should actually say it here because agencies look at this now, and if I looked at this as an agency head, I was at the IRS or any place else, I would think Social Security is an even better example. Would think anything that goes into the court system, I am expected to put up on our website, and I don't think we want to do that, or at least I wouldn't want to recommend that. So that's my comment. And I think we ought to take
suggestion, Alan. Actually, Andy Vollmer had made proposed a recommendation, proposed the addition of an additional recommendation a little bit further down the page. So I actually have his language here. Maybe we could put it in recommendation 1. His proposed language was something to the effect of agencies with a large volume of litigation in federal district court could decide not to post documents from every case, period. They could post examples of filings from routine litigation and all or a major portion of the filings from cases raising important or unusual questions.
Kristen, my skills as a stenographer.
Yeah, no problem.
Keep up with that.
Find the language in Andy's comments that he submitted, but starting from there, they could post examples of filings from routine litigation.
Filings.
And all or a major portion of filings.
Kristen, can you hold on? Whoever is, you guys make sure to mute your microphones if it's not too much trouble.
Yeah, we're getting feedback from somebody.
All right.
So all or a
Kristen.
portion of the filings. From cases raising important or unusual questions. Up on line 64, I think it's supposed to be federal district court, although, it could just be federal court. This was Andy's proposed language. But okay. So Alan, welcoming comments from everyone. Alan, does this accomplish your goal?
That's okay. Yeah.
I saw Robin Greenhouse and then Drita Tanuzzi.
I'm going to let Drita go first.
Okay, Drita, go ahead, please.
She may be on mute.
Yeah, I think Trudy is on mute still.
Oh, there you go. Okay, thank you very much, whoever unmuted me. We recommended some language in the preamble because I thought the whole point of this recommendation, and I apologize that I wasn't here for the first meeting, but is to provide the public useful information that may have a bearing across the board, not, you know, a unique or routine kind of issue. So we put some language in there that so some cases relate to matters that have unique circumstances and facts that may not have a broad application to others. Generally, this recommendation is focused on agency litigation materials that would have a broad application and would have bearing on the agency's regulatory and enforcement activities, because I thought that was the point of this recommendation.
I'm a little bit not entirely clear on, you know, the language that you, other people may feel differently. The language that you've proposed for that first paragraph in the preamble, I wasn't entirely clear on exactly what it was trying to get at. I guess my question for you would be, which of that language would you want to move to this recommendation one? Or are there particular edits to the language that's currently up on the slide that you would make to reflect your understanding?
Well, I like the notion of
routine.
Yeah, I like the notion that routine cases are not what we are driving at. And as I said, we have over 25 to 30,000 cases a year. More than 80% of them involve unrepresented taxpayers. They're fairly routine cases, nothing precedential about them. And so any kind of settlement or any document and publicly filed document in those cases really wouldn't have a bearing on the agency's enforcement action, except that the agency is actually taking an action. So that's my point. So I think maybe routine cases might cover it, or routine or cases that do not bear on the agency's regulatory or enforcement activities, objectives, purposes, whatever you want to. So Robin, did you have comments in that?
You're suggesting we shouldn't be posting filings from cases raising important or unusual questions?
No, we should. That's
okay.
what the purpose of this should be. Not on routine cases that really don't expand the knowledge of the public about what enforcement activities the agency is taking.
Given the use of the word could, in terms of could post filings from examples of filings from routine litigation, is that permissive enough to accommodate, you know, your concern?
Yeah, I suppose. I mean, the whole thing is permissive, right? So I think earlier we talked about how.
Do you think I'm too far? I mean, is there anything I should be doing in here?
Matt, you've gotten. What? I don't know if you intended to unmute. I've got Brady Tonsing next from DOJ. Brady?
Yeah, is my mic working? Can you hear me?
Yes, we can hear you.
Okay, so my concern on this, first of all, I appreciate that ACUS changed the recommendation to be this permissive subjective review at the agency's discretion. These additions seem to be moving more toward a presumption that an agency will be producing records as part of that consideration.
Would it help if we put something like put the words for example, comma, before they could post examples of filings?
I'm not sure. It may be something along the lines of, if an agency does decide that it would like to provide access to these materials, agencies with large volumes of litigation may not want to post documents from every case. Something along those lines. I don't see what else. Okay.
Sure. So perhaps before that sentence where the cursor is, how about should an agency choose to
To post such material,
post such material, comma, agencies with a large volume of litigation?
those with large volumes of litigation, with a large volume of litigation.
Sure. How about agencies with,
Yeah, may not want to post documents from every case. Again, I reserve the right to let this refrigerate and be refined in the calm of a new day.
I will suggest that could decide is cleaner than may not want to. And I'm not sure that it means anything differently.
Right. Okay.
Yeah, could decide not to post documents from every case. How about instead of those, how about an agency with a large volume of litigation in federal district court? Because
Kristen, can you say that again?
otherwise we're singular. We've got should an agency choose to post such material? And we've got a large volume of litigation, so it would seem more consistent grammatically to say an agency with a large volume of litigation. Okay. Rada.
This is
From Department of Labor.
Hi, yes. I just had a question about limiting that sentence to federal district court litigation, but not the rest of the recommendation. It just seems to me like a lot of, at least at the Department of Labor, a lot of the more routine litigation happens before an administrative law judge, not in district court. So, that might limit it in a way that we're not intending.
I seem to remember talking about ALJ hearings last time, and I don't remember what we talked about. But for that matter, it also does occur to me that it shouldn't be limited to federal district court because of the fact that a lot of agencies don't go in front of federal district court with their policy type litigation positions. They go straight to federal appellate court.
Right, yeah, at least like in the OSHA context, we go from the Occupational Safety and Health Review Commission directly to the Courts of Appeals. So we do skip district court altogether.
Yeah, so is federal court better?
I think so. I'm not sure if federal court would cover the ALJs, and I don't know if we intend to cover the ALJs here.
That's a very good question. Does anybody have any perspective on whether we intend it? Mark, was your intention in drafting this originally to include ALJ hearings?
No, decidedly no. This is about federal court litigation, not administrative hearings. We have done a recommendation on administrative hearings and materials from those hearings. I believe it's 2017-1, if I'm not mistaken. There's a separate comment, I forget who made it, that we should cross-reference it in this recommendation to remind people of it. I think the suggestion that was just made is a good indication that that comment is a good one, and we should consider it. The committee should consider it, I should say.
Do you have any thoughts, Mark, as to where a reference? I don't think we usually reference other ACUS reports in the recommendations themselves. Is there a particular place in the preamble that you think that reference should go?
I haven't given that a tremendous amount of thought. I imagine the committee could come up with it.
Okay. How about this? Can you flag that for when we get to the preamble? Because I'd like to stick with the recommendations. Can you flag that we need to find a place to put that reference? And then when we get to talking about the preamble, we can find a place to put it. Thank you. That'll be very helpful. Okay. And I assume, so I think I think that's right. So if we're not talking about ALJ materials, if we're only talking about federal court, we do want to strike district, I think, because it's well taken that a lot of agencies go straight to appellate court. I seem to remember in the various comments, and I don't remember who, somebody suggested that it should only be Article 3 courts and not Article 1 courts, for that matter. I don't know if anybody has any perspective on this
Kristen,
particular question. Robin, I see your name on the list.
What I wanted to talk about was the other half of that sentence, which talked about that you might, instead of, in addition to posting routine, all or a portion of the filings raising important and unusual questions. And I'm concerned that that could get into sort of government deliberative process as to what you think are the important cases and raise important questions.
Well, since the whole thing is discretionary, I think the whole point is to allow some discretion in that regard. But let's come back to that in just a second and let's try to resolve this federal court point, and then let's come back to that, because we should revisit Robin's suggestion here, or Robin's concern.
I have a comment on that point, the federal court point.
Alan, please go ahead.
2 points. One is sometimes federal agencies and the Justice Department file in state courts, for removal purposes or because they're filing amicus briefs or other purposes. So I wouldn't want to limit it to federal courts. Number one. Number two, I do not think we should limit it to Article 3 courts. The Veterans Administration there are various proceedings in the Veterans Administration. Many of the cases would be excluded because of the routine litigation exception, which I support. But cases that go to the Court of Veterans Appeals, which is an Article 1 court, or the tax court, which is an Article 1 court, sometimes they're very important issues there that are not routine and that the public ought to know about them. So I would not limit it. It's strike in federal court, have large volume of court litigation. Maybe we could say court litigation to be clear that we're not talking about agency litigation.
Mark, can I just ask you a quick question? Do you know if the recommendation on agency adjudication materials excluded Article 1 courts?
I don't know off the top of my head. I can look.
It would just be a consideration. I think if it's not covered by that recommendation, I think Alan's got a good point here.
Sure. I will look at that over the break and I'll report back to the committee. While I'm sharing my screen, I can't do a lot of searching.
Sure. How about this? Let's tackle Robin's suggestion with respect to the next sentence, and then I was starting to think that we were coming up on a good time to take a break. So so Robin, my recollection of your comment is that you're concerned that by saying all or a portion of the filings from cases raising important or unusual questions, that is imposing a burden that might intrude upon deliberative process concerns. Do I have that correctly?
Yes, you do. Yes. It's one thing to exclude categories of cases, like Drita mentioned, pro se taxpayers, or you could identify categories like in the tax court. They could be cases that end up with tax court TC opinions, which means they're the court's opinions as opposed to lower authority. You could do that, but once you start identifying certain cases that you think are more significant than others, I think that opens you up to public criticism. You're picking and choosing. Why are you choosing these specific cases?
Well, it is a fair point that I recall hearing from our last committee meeting, that some people were concerned that agencies would pick and choose they would cherry pick among their litigation, the things to put up to make them look good, as opposed to, things that they didn't think necessarily made them look good. I'm not sure how to accommodate those concerns vis-a-vis the language that is up on the slide, and I would welcome suggestions in that regard.
I mean, my suggestion would be to take out the sentence. And you just have the prior sentence, which is agencies with large volume could decide not to post documents from every case. And then they can figure out how they want to do it without sort of putting out here, this is an option.
So Andy and Alan, the two of you were collectively sort of the genesis of this second sentence.
Well, I would object to taking out the second sentence. I also think that the chance of actually intruding onto the deliberative privilege is extremely low. One can apply objective factors to identifying important cases or unusual legal question cases. So I don't, but what we're trying to do is first of all, it's all within the context of agency discretion. So everything's at the agency's discretion. They get to pick and choose, and we're trying to provide some guidance about what we think is a good idea if you're going to have one of these websites. And the routine litigation idea, I think, struck a chord with many people because certain agencies have a lot of cases, and we're not talking about putting up every document from every case. So the routine litigation, I think, makes a lot of sense for carving out. And then it's a question of defining the types of proceedings that we think are the ones that would be more beneficial for the agency to put on the website than others. And so I took a shot at it. Actually, Alan Morrison raised this question as well. I took a shot at it. I think it's perfectly reasonable to use the phrase important or unusual question litigation, but I'm happy if people come up with better ideas. But what we're trying to do, I think, is offer some guidance to agencies to sort through their litigation portfolio and put up ones that are helpful to the public and not worry about others.
Alan, do you want to weigh in?
I think Andrew makes some good points. I don't see there's anything very objectionable about it. We could always do what we often do, is temporize by putting this suggestion in the preamble. But I think it's a perfectly sensible suggestion, and it may be helpful. And so, on balance, I would prefer to leave it in rather than take it out. But I wouldn't fall on my sword over either option.
So, Kristen, can we maybe broaden it a bit and just tie it back to filings from cases that would have a bearing on the agency's regulatory or enforcement activities? Just sort of make it a little squishier.
I think the clause is supposed to go at the end in lieu of raising important or unusual questions, not in the middle. Is that right, Drita?
Yes.
Rita, can you repeat the clause one more time, please?
Filings from cases bearing on the agency's regulatory or enforcement activities. And so we in council may decide to just focus on novel issues, but someone else might decide to focus on whatever the language was that we put in before, important or just giving the agency a little more control over what they post.
Barbara Silverstone from the National Organization of Social Security Claimants Representatives. I see you have a comment.
Yes, thank you. I work mostly with cases within the Social Security Administration. I'm not a litigator myself, but one way to limit some of these cases would be to have it only be cases at the circuit court level. There are, thousands and thousands of cases at the district court level and fewer at the circuit court, and those are the more important ones in the Social Security Administration, Social Security world. I don't know if that works for other agencies.
I'm not so sure that that works so well across the panoply of agencies.
Okay, and I was just raising that. I don't know much about it.
No, and that's wonderful, and I appreciate it very much. But I'm just not sure. I take your point with respect to SSA. I'm just not sure that that's necessarily the case across all agencies in that regard. I can think of district court litigation that where you might want to see the filings in that regard. Okay. I tell you what. I'm of two minds on this on this particular bit myself. Brady Tonsing, you've got a comment here.
Yeah. Well, first of all, I mean, I'm weighing in on some of this stuff, but I have some concerns about this proposal as a whole. And again, I got to say, I appreciate that it's been qualified. But one of the purposes is to increase the public understanding of their legal obligations. And just building on, I think it was Robin Greenhouse's comments, I'm a little concerned that that perhaps an agency could use the posting of briefings to perhaps undermine what I believe is even ACUS's position on guidance documents, and perhaps try to move toward an informal guidance for regulatory interpretation. And it's a lot easier to get approval for a brief position than it is to issue a regulation. Does anybody have a concern about that, and should we address it?
I know I have my thoughts, but as chair, I'd like to hear other people's thoughts first. Not hearing any. I mean, my own view on this is at least as regards litigation positions, whereas guidance documents get Skidmore deference and regulations get Chevron deference, litigating positions usually don't get much of anything. So I personally am a little bit less concerned about agencies utilizing litigation briefs to try to steer regulatory agendas. To some extent, that's kind of the point of making the litigation briefs available in the first place, is, to provide those sorts of signals, albeit in an extremely non-binding kind of a way. Maybe other people have a different perception about the point of the recommendation generally.
True, but we're proposing that only one side be presented, and we're specifically saying that the other side of the adversarial process not be presented to the public. And as former defense counsel, I certainly would be paying attention to what an agency's position is, and so I imagine the public maybe as well. And if you don't have that full picture, it could be used to stake out a new regulatory position that agencies would expect private litigants to abide by. For example, ATF does this routinely, where they issue positions, but it's not necessarily in court. But the ramifications of failing to abide by their position are enormous.
Oh, sure. The difference between the status quo and post this recommendation, though, is that instead of only insiders who have access to PACER being aware of that litigation for purposes of guiding their behavior, general members of the public have access to the same information after this recommendation. I don't think we're going to change agency efforts to try to influence people through litigation. We're just going to make it more transparent.
An explanation page on the agency website explaining the types of litigation that an agency is involved with, presenting exemplars, presenting landmark cases, and then presenting a link to PACER with an explanation of how best to find agency litigation materials would be the purest, best way to have the public get access to it in an unvarnished, unbiased way, see where the agency is, see how courts have ruled, see how parties have ruled. And for private individual people, there's no charge for using PACER unless you print an enormous volume of material.
I'm less familiar with PACER. Mark, I know that in drafting the original report that you had looked into that particular idea in some sense, and maybe you have some thoughts that you can share here in connection with what Brady's talking about?
Sure. In a perfect world, yes, everyone would be fluent in PACER and able to use it freely and easily. Ours is a less than perfect world in that department. It's true that you have to access, I forget whether it's 250 or 300 pages of documents before you are formally charged on PACER. But the reality is that 300 pages of documents, especially when you don't know what you're looking for, is not that much. It's quite easy to go through 300 pages of documents before you find the one you're looking for. Secondly, PACER requires you to input your financial information. Interviews with a number of people and public citizen groups have suggested that a sizable chunk of the public is simply not willing to provide public information for something like, or their financial information, billing information rather, for something like PACER. And then third and finally, although PACER is a wonderful service, especially for those of us who have a case number and know exactly what we're looking for, it is somewhat limited to the extent that, I should say it's somewhat limited as a service for people who are simply looking for litigation on specific topics or involving specific agency action, but don't have much more information than that. There's only so much you can do. For example, I think the example given in the report is if you want to know something about the Fish and Wildlife Service and you understand that they are litigating some new rule, it's very hard to search PACER for the title of that rule, for example. PACER won't yield a result. So just in terms of winnowing through the cases to find what you're looking for in the first place, can be costly, it can be time consuming, there's an information burden, and oftentimes, unless you have a case number, which to some extent defeats the purpose of, that's the reason we have this project in the first place, is because people often don't have a case number. PACER is of limited utility in that regard. I hope that makes sense. Sorry for going on.
No, that's great. I appreciate it. I will readily concede that my own preference, I think, was for the unique, issues language, but I'm not hearing anyone objecting to the bearing on the agency's regulatory enforcement activities phraseology at the very end of this recommendation as it is currently up on the slide. Is this our preferred language before we take a break and then move on?
Well, as Volmer, could I just add a thought? So
yes, please.
I don't find it particularly helpful. I thought that we were going to use that language at the very beginning of the preamble to define the universe of documents for an agency's website. So all the cases that are listed on a website are supposed to bear on the regulatory enforcement activities. So I just don't find that a limitation that's helpful. So I'm not sure it serves the purposes of the person who proposed it. So as I said, maybe there's better language than the important and unusual questions that I proposed, and I'm all ears, but I find this language way too vague and not limiting at all.
I will say I find it rather inexplicably duplicative of the first sentence as well. And again, kind of prefer the important or unusual questions phraseology myself. I don't know, is this the kind of thing where we take a vote, Matt, or is this the kind of thing where we just try to, because the voices that are speaking are sort of equally split?
Reeve, what do you think here?
Yeah, it's up to you, Kristen. It may well be that taking a vote would be the best way to go. And it seems like since most people have their camera off, probably it would be something you do through the chat feature, I guess, would be the easiest way to go.
Okay. I'm going to propose, so we've got two different bits of language here. One of which would say they could post examples of filings from routine litigation and all or a portion of the filings from cases bearing on the agency's regulatory or enforcement activities. The other being all or a portion of the filings from cases raising important or unusual questions.
And Kristen, this is Drita. There's a third option which was proposed to delete that sentence entirely.
Okay. Or deleting the sentence entirely. So how about we do this? Why don't we, I think it probably makes the most sense to agree, to choose between phraseologies and then decide whether or not to delete the sentence entirely. Unless somebody thinks we ought to do it the other way around, that's the way that makes the most sense to me. Any objections to going in that order?
The chair gets to decide.
Okay, so let's start by deciding between bearing on the agency's regulatory enforcement activities and cases raising important or unusual questions. I think the way to do this, do we want to, I forget what we decided last meeting. Do we want to try to raise hands on the screen, or do we want to have everybody vote yay or nay in the chat? Yay or nay in the chat's probably the most reliable. So if you are in favor of bearing on the agency's regulatory or enforcement activities, please put yay in the chat if you are a voting member of the committee. Mark, are you tracking this?
Kristen, are there any, I don't know if it was you or Mark had raised a question about the eligibility of a member to vote. Are we all clear as to who, is Mark at least clear as to who all the voting members are?
Yes, I have a list of the voting members.
Okay, and there's no, there may have been a question, that question is not live anymore.
I have answered the one question about, one member asked a question about, or one person asked a question about whether he was a voting member or not.
Okay.
That question has been answered.
Okay, thank you, Mark.
Yep.
Okay, I have I'm seeing 3 votes in favor of the first option. How about if you, this is getting confusing because if I tell everybody else to vote yay, then, okay. If you are in favor of the second option, please type yay on the second option into the chat. Unfortunately, unlike Zoom, this does not have a way to raise hands, so we're simply going to have to do yay on the first option, yay on the second option. So yes on the second option, please indicate as much in the chat. There are more people in the room than 5. Does that mean everybody else is abstaining? I have 6 votes total, 3 for the first option, 3 for the second option. Is anybody else interested in voting?
How about you?
If I'm breaking the tie, I'm going to vote for the second option. Okay, that seems to be where we are at then. So with that language, our other option is to delete the sentence entirely. Here I will do yay. What?
Can I
Go ahead.
speak to that for just a moment?
Absolutely. Please go ahead.
Thanks. I was quiet earlier because I was doubting my own memory, but I went back and looked at the materials, and I just wanted to point out that this whole discussion we've been having about having agencies only post significant or important or unusual or whatever phraseology is used. I think this is driving the whole recommendation in quite a different direction from where it was last week, excuse me, at the last meeting, where I understood it to be more in the nature of creating a comprehensive archive of these litigation materials. And I went back and looked at the report again, and I think that's what the report is directed at, which is not to say that that is the best idea and this is a bad idea, but it just seems to me these are two very different ideas. It's a very different thing to say the agency should create a comprehensive archive of its litigation materials and saying the agency should create a website which will highlight significant litigation materials. So those are just very different directions. So it seems to me this choice to keep the sentence in either first or second form or delete it, that's a very important choice. I wasn't so concerned about the precise wording, but whether we delete the sentence or not, that is significant.
Alan Morrison, you've got a comment.
I agree with John that it is a change in direction. But on the other hand, we did not have the benefit, and I think Mark did not have the benefit of the comments from high volume agencies like SSA and the IRS about what this would do if we had a comprehensive archives, as John suggested. And my view has changed on this once I realized that, thought about those high volume agencies, which surely we should not have every time anybody goes to court. By the way, immigration is a similar one. They have many of the same situations in which the only question is whether there's substantial evidence to support the findings. So I agree with John. This is a change, but I think it's a change for the better.
I will make one observation here. I agree with Alan's. I agree with what both Alan and John have said. Originally, Andy had suggested that these last two sentences be set up as a separate numbered recommendation. I wonder if we, in the middle of this, starting with the word should, if we drop that down and made that a new recommendation too, then we go back a little bit to the default recommendation being agencies should consider providing access on their websites to litigation materials, but then a second separate recommendation acknowledging that an agency with a large volume of court litigation could take a different approach. Would that shift the emphasis back the way it was originally while simultaneously giving voice to the concerns of those agencies with large volumes of litigation?
I think it would do that, yes.
Okay by me either way.
Okay. Before we can decide that, I guess we need to decide whether we're deleting this last sentence, because that's still an option and we were going to vote on that. And I think what I'm going to say, with the acknowledgement that we may move this to a second recommendation, we need to hold that vote. So if you are in favor of deleting the sentence, put yay. If you are against deleting the sentence, put nay in the chat, please. Okay, again, we seem to be, actually, I've got 2 people to 3 people here. No, I've got 3 to 3. Any other votes before I break the tie? Okay, in breaking the tie, then I'm going to vote in favor of keeping the sentence. So the vote is 4 to 3. At which point, with these two, I'm going to suggest that we drop the last 2 sentences of what is currently as recommendation 1 on the slide and make it a separate recommendation 2. Does anyone object to doing that? Okay. Hearing no objections, I think we're done with 1 and what is now number 2. Before we move on to what is now number 3, I think we need a 5-minute break. So how about we meet back here? We'll make it a 7-minute break, and we'll meet back by my clock at 2:25.
Hello, can you hear me? Hello?
Yeah,
Oh,
please
yeah,
go
this is
ahead.
Paul Cameron. Yeah, Paul Cameron, our senior fellow. I was not able to go in the meeting, and I did the call in, but it said I could not talk. But then Mark just emailed me the number again, said it was activated. I'm sorry I wasn't available at the first meeting, and I have to go at this break, but I just wanted to make a question regarding the definition of agency litigation materials. Just to clarify, it says, in the definition that it does not include court filings by private parties. So am I to understand that we're only recommending that the agency post only their filings, but not the party who would be a plaintiff or defendant, their filings? Because, for example, I'm with the Federal Election Commission, which I recommend is a good litigation website. They list their open cases and then selected court cases like Citizens United and so forth. And when you click on it, it's got all the briefs filed in the case. Motion for summary judgment by the private party, opposition by the FEC, and so forth. So do I understand that we're only recommending that the agencies post only their publicly filings?
Yes, the very strong consensus from our last meeting was that asking agencies, putting on agencies the burden of posting private party filings raised a number of issues and burdens that made many committee members uncomfortable. This is not to suggest that an agency should never post private filings should the agency choose to, but the general consensus from the last meeting was that we really wanted transparency with respect to the agency's communications, even though we acknowledged that having both sides of the story might be even more useful.
Okay, well, I just think that I just disagree with that because, if a party files a motion for summary judgment and the agency files an opposition, you read their opposition, you go, well, okay, that's their side. Let's see what the private party argued and let the public, in terms of transparency, see what was decided. And of course, the court decision would usually say, here's what both parties argued, here's what the judge decides is going to be the decision in the case. But it seems to me awfully not transparent just to have only some of the briefs. Now, sure, if it's too many things to file, but usually in a lot of these cases, if it's like a question of law, you have motion for summary judgment, opposition, reply, etc. I'm not saying we should file everything that you see on PACER, like notice of appearance, minute orders about scheduling things, but it seems to me, and again, I recommend the FEC website where they post these things. I mean, it's not that much to post the key documents in the case, and so I think it's only giving the public a partial view of what the case is about, just to give the agencies filings. So
I understand, and I understand the argument completely. And at our last meeting, we discussed this issue at fairly great length, I believe, if I'm recalling correctly. And the consensus at the time was that we were not going to require the filing of private party documents, or we can't require anything, but we were not going to include in the recommendation the filing of private party documents. I'm a little bit loath at this point, with all that we have to talk about, to go back and revisit that discussion again.
No, I understand, but if I can you just give me a 1 or 2 sentence rationale? Is it because it's too much burden on the agency to post an opposition to summary or some of the key documents? And if they're posting things from the court case as it is, I don't see what the extra effort is to post the other key documents about a case. So was the rationale, the consensus, that it's too much of a burden on the agency to do that, in which case the FEC does it very well, and I'm not sure what other agencies do it. So can you tell me what the rationale was for not having the private parties filing?
Mark, can you help us out here? Do you recall all of the particulars of that conversation?
I won't say all of them, but I recall a fair number of them. And the two rationales that I think were most forcefully advanced. Number one was the burden on the agency in terms of pure administrative responsibilities, not just in the sense of having to file opposing parties briefs, or not file, I'm sorry, copy and provide access to opposing parties briefs, but also to potentially have to provide access to amicus briefs that are especially important to fleshing out an issue. People weren't sure where to divide that line. And in some instances, you have, particularly in certain district court proceedings, even some agency district court proceedings, you have multiple rounds of briefing on multiple distinct issues, and you wind up with hundreds of pages of briefing. And at some point, it just became potentially too burdensome. The broader problem with filing private or publishing private parties litigation filings is that it would require, some people thought it would require agencies to review those filings on a line-by-line basis to see whether there is private or otherwise confidential information in the filings. The government can do that easily with respect to its own briefing and its own filings. The government is not as able to do that with respect to private parties filings. And then a third rationale for limiting the project to materials filed by agencies or courts is that those materials in some circumstances have unique authority in terms of either setting forth what the law is, swaying, in terms of deference, depending on the nature of what's being filed. In some cases, an amicus brief filed by an agency might even be entitled to Chevron deference. Beyond that, the government agencies are just in a unique position to set forth their own regulatory and enforcement priorities in a brief that private parties just don't have a similar heft to their briefing. They don't get to say what the government's enforcement priorities are. They can speculate about them, they can argue about them, but that's different than hearing from the government. And so for those reasons, the balancing analysis, because the points you raised, Paul, are significant, and I don't by any means mean to diminish them. We recognized, I think the committee recognized last time, that this involved a balancing, but on balance, they came out in favor of allowing, but not requiring or even endorsing a requirement that agencies publish private litigation materials. Does that make sense?
Well, I mean, I understand what you're saying. I just disagree with the rationales. I mean, it seems to me that if a document is publicly filed that we can get on PACER, that same document should be able, if the agency has the wherewithal, to post it as well. And like I said, the FEC does that. I can understand, like, you don't want to put amicus briefs or everything that's on PACER, but for goodness sakes, the main documents, the motion for summary judgment, the opposition and the reply, those kind of key documents, I think are what in the public interest and should be. I mean, that should be the goal. So I would just think that as a recommendation, we want to recommend that they do that and say at a minimum, put your own agency documents. But the committee recommends that you post all the documents that are, not all the documents, but all the major documents on the case. And again, I just, I sent you the link to the FEC website. And if you're going to do something here, at least put a footnote in the preamble or the recommendation to a couple agency sites as best practices, or here's what we think you should be striving for, to give them some guidance as to how to do it. So again, I'm not familiar with all the agencies. You all went through that before, but is that the general practice for the agencies that do post the litigation documents, that they only include their filings and not the opposing party's filings? Is that the norm?
There is a wide range.
You
and
did
it
the survey.
depends. Yeah, it depends on the nature of the agency's litigation portfolio and other internal and kind of agency-specific considerations. It's because there's such variability across the administrative state that kind of a blanket recommendation about do or don't do this with respect to private materials filed by private parties is harder to.
I understand. Yeah, I don't mean to be, have to be do or do not, but at least, suggest that they do. But if they don't have the resources, whatever, I don't see why we should artificially say, and do not put the private parties litigation. So look, I'm sorry I wasn't at the first meeting. It sounds like this was the consensus. I just have an objection to being limiting it only to the agency's documents. Again, I apologize for not being on the early meeting, and I'm sorry I'm going to have to leave now. But that's my recommendation to have the best practices, cite the FEC, and then also at least put a footnote in. Here's a couple agencies that do what we think they should do. But hey, if you're too busy or too much work, at a minimum, put your
Here's what I'm going
documents.
to suggest, because I do think we need to, I know you need to leave, and I do think we need to move on. And this was something that we had decided in our last meeting. My suggestion would be that at this point, that if you feel strongly about this issue, you propose some language at the plenary session, and then it can be debated as by the plenary body. I think the committee has decided what it's going to do or what it's going to recommend in this regard. And so, in the interest of moving forward rather than backward, I think that's where we're going to have to leave it for now.
Yeah, no, that's fine. I understand that as well. But anyway, again, apologize for being late to the game here, so to speak, but appreciate all the work you're all doing on this. It is important.
Not at all. We appreciate your views. We really do. With apologies to the group, I do need to take a very quick break to get some more water. I will be back momentarily, and then we'll start up the meeting again.
Thank you all. Bye-bye.
This conference will now be recorded.
It's Andy Vollmer again. I'm sorry I was out for a couple minutes, and if you reported what the committee's decided on, including private party filings, could you just let me know?
Sure. I mean, the conversation we were just having, for those people who missed part of it, it was Paul Kaminer, right? Who missed the last meeting and felt very strongly that we should be recommending that agencies include private party materials among the agency litigation materials posted on their web pages. And my recollection, and I believe it was Mark's recollection too from our last meeting, was that we debated that precise question at some length at the last minute or at the last meeting, and that the consensus at the time was that while we saw that there might be situations in which posting private party materials might be useful, nevertheless, the consensus was that we were not going to recommend that agencies post private party materials, that we were going to limit the recommendation to agency materials. And so, with respect to Paul, while I understand his viewpoint and think it is a valid one, nevertheless, I'm, having reached that consensus as I understood it at our last meeting, I'm loath to reopen it and relitigate it again here, and would prefer to move on to some of the other issues that we have open based on where we stood after the last meeting.
All right. I don't recall that consensus. Maybe I just missed it or forget. But
we didn't take a formal vote. It was just, I think it was my and Mark's sense from the room, so, as it were.
Well, my memory is that there were a couple of different points of view. I proposed, and I think some others agreed, that encouraging agencies to put some private party filings on the website made sense, because otherwise you're not going to fully understand the agency's position in certain circumstances. And I recall people talking about selective posting of private party materials, and that's how I remember it, but I could be wrong about that. And if the judgment of the committee is we've decided and let's move on, fine, but could we at least put in the preamble that an agency that wants to post materials is free to include private party filings on a selective basis, and that the preamble and the recommendation do not exclude the possibility of posting private party filings.
Mark, I don't have a precise recollection of whether we even specifically mention private party materials in the preamble. Can you shed some light here?
I believe we do mention private party material. Yeah, the last sentence of the first paragraph, the definition does not include court filings by private parties. In fact, I'll just share my screen here. So there's the last sentence. With respect to John's suggestion, I think that, as I recall it, the split last time was over the extent to which we wanted to encourage the posting. I think it would be hard for anyone, I shouldn't say that, but I think it would be, I don't think it would be as much of a problem, and I doubt as many people would disagree with something along the lines of agencies are free to, post these things agencies have discretion to post private litigation filings. That doesn't bind agencies to do or not do anything. The issue last time was the extent to which we wanted to encourage the filing of privately filed materials, and that is to some extent a matter of semantics, but it has important implications potentially for reasons that we discussed with Paul Kamener just now.
Sure. I mean, as I look at the preamble up on the screen as it currently reads, the second paragraph then goes into all of the reasons why public access to agency litigation materials is desirable, with a particular emphasis on the public part as opposed to the private party filings, which seems to suggest the orientation of this recommendation. If somebody wants to propose language to go into the preamble to say something about private party filings, I'm happy to entertain it. Before we do that, though, we still need to get through the recommendations. We're an hour and a half into this meeting, and we've only managed to make it through one recommendation. So, in the interest of trying to avoid having a third meeting on this particular set of recommendations, I would like to try to move forward and make this as efficient as possible, trying to get through these additional recommendations and then turning to the preamble. So perhaps, Andy, you could draft while we're talking about the third recommendation, maybe you can draft a sentence or a footnote somewhere to propose for the preamble with respect to private litigation materials.
Yeah, I'm happy to do that. I've already written something, but what's the right way to send it, since the chat's not?
Why don't you, so that we have it, why don't you email it to Mark?
Yep, perfect. Now, so is this on the free to include idea, as opposed to stating that we're some sort of encouragement? So the draft you want is not to encourage, but is to say doesn't stop agencies from including.
You propose the language how you want to propose the language, and then we'll debate it from there, if that seems reasonable. I mean, I think your sense is mine as well, but at the same time, that's I think that's going to be the easiest and most efficient way to go about doing this, if that's okay.
Oh, it's fine. Thank you very much.
Sure. So moving forward to what is now recommendation 3, we have a few proposed changes to this. First, we've got, let's see, bear with me here, from Alan. Alan, I've got a comment from you here, but I don't have any changes. I've got at the end of I've got a comment with respect to B, and I have a comment with respect to F. And I'm having a little bit of difficulty deciphering them. So I'm wondering if you can help me out here.
Yes, I wonder, since you focused a moment ago on big questions, whether we could say something about what we expect of the Justice Department and agencies that have the Justice Department as their principal litigating partner. The question was, I think, well, I suppose the Justice Department is also worried about criminal cases too. We haven't said anything about that and whether that arguably comes within regulatory or not. I'll leave that up in the air. But the bigger question is, in our view, if the Justice Department publishes a case on its website, is that sufficient? Or conversely, if the agency does it, is that sufficient for the Justice Department? And I think, I don't know what the answer is, but I urge that we be clear on that question.
Do you have particular, I think that general, so Brady, I know that you were looking into, access by client agencies to litigation documents. I don't know if you have any intelligence that you can share in this regard. I don't want to put you on the spot.
No, feel free to put me on the spot. I'm trying, I'm not sure what the basis was for that assertion, saying that and I remind me, and Mark and I have talked about this, and I'm just trying to discern it. Was it an assumption that the department wasn't providing the IRS litigation materials in one case? I mean, I know that the department's position is that it provides its client agencies litigation documents. I mean, there's some cases where I'm sure that the agency is not interested in seeing those updates on those cases, but I'm certain that if an agency wanted to be informed and get documents, that they would be able to get them on a regular basis.
This is Robin Greenhouse, because I think he's referring to the comment I made, which is that while in cases in which the Department of Justice Tax Division is defending actions taken by the IRS, the attorneys in the IRS do not maintain a pleading file from the Department of Justice. What's filed in that case. They may get courtesy copies of some of the important pleadings that are filed, but their only access would be going back to the attorney in the Department of Justice who's handling the case to ask them for these documents, or else to go on Pacer themselves to get the documents. So that was my point, which is, in cases that are being handled by the Department of Justice, if the agency doesn't keep a pleading file as a matter of course or a matter of process, then asking them to do this didn't make sense.
This is Brady. I probably missed the most important part of that. I apologize. There's a thunderstorm here that knocked me off the internet for a second. Do you mind just repeating the very beginning of that so I can respond?
So what I was saying is that with respect to tax matters that the Department of Justice handles on behalf of actions taken by the IRS attorneys that will provide assistance do not keep formal pleading files. They do not, maintain files that have all of the documents that are filed with the court. They may receive on occasion courtesy copies from the attorney at the Department of Justice, but without having a litigation file, that would be unreasonable amount of work to now put in a new process where IRS attorneys have to maintain pleading files in order for them to maintain this page.
Okay, I don't know what the arrangement is, but specifically between the tax division and the IRS attorneys, but otherwise, I'm not sure what the ask is, because would the department then be tasked with posting all of these filings, or would they would send them to the IRS, and the IRS would then decide whether it was in their interest to then post them publicly.
And now, my point is that when we looked at this, we look at this only in the context of the tax court. That's the court that we litigate in. And if the Department of Justice had decided, based on these recommendations, to create its own website and to include, tax refund cases or summons enforcement cases or, other types of proceedings, then that would be in their bailiwick.
Is anybody seriously suggesting that the Department of Justice, that this recommendation would ask the Department of Justice to create a website? I don't think that's ever been contemplated. And if I were the Department of Justice, I would say no way.
That was my understanding too, was that in the last meeting, we basically said this is not intended to dump a litigation webpage for the entire government onto the Department of Justice, but rather that we wanted individual client agencies, that was the goal, because somebody who's got tax litigation going isn't going to go to the Department of Justice website. They're going to go to the Internal Revenue Service website.
So, Kristen, shouldn't this be limited to cases that the agency actually litigates on its own, as opposed to refers to the Department of Justice? That's what I thought the exercise was. Not that we would then have to go to the Department of Justice to get all of their pleadings, or to PACER, so that we can make all those pleadings available when we were not the trial attorneys in that case.
Well, and I recognize the IRS may be an unusual case in this regard, but, I think the general, and I ask that other members of the committee correct me if their understanding is different, and I understand Drita's understanding is different. My understanding from the last committee meeting was that we didn't want one giant Department of Justice website that covers all the agencies where the Department of Justice is primarily responsible for conducting the litigation, because that is not where people would go to look for, not only would that result in a huge amount of, sort of throwing everything together on the Department of Justice's webpage, but that correspondingly, if you're litigating, an environmental case, or you're, that originated in some sort of EPA action, or you're litigating, a fish and wildlife case that originated in something that they did or something like that, even if DOJ is running the litigation, you'd go to the other agency's website to look for the documents. That's where the members of the public would go to look. And so that was the most appropriate place to have agency litigation web pages.
Let me just give you a thumbnail of the enormity of what the department handles. They have, at any one time, currently have over 33,000 active cases right now. That does not include cases that are handled by the IRS's tax division. It does not include the independent litigation that's handled by the 93 United States Attorney's offices. It does not include independent actions that are pursued by agencies without DOJ involvement. There is a document that is 700 pages long that talks about the dynamics of when and where the department represents client agencies. And it's incredibly complicated.
Sure. I presume, and tell me if I'm wrong here, Brady, I presume that when the Department of Justice is litigating a case on behalf of a client agency, that the client agency's personnel, whether in the general counsel's office or otherwise, are at least kept in the loop.
Well, kept in the loop. I'm certain that there are appropriate briefings that are done. I do not know the dynamics of every type of case or every type of litigation. Sometimes an agency second chairs a case. Sometimes they don't. Sometimes the agency has very little involvement. I imagine that there are cases that the agency is not interested or doesn't have the personnel to be able to stay abreast of the litigation that's ongoing, or they have general policies that govern how litigation is handled regarding individual cases, and therefore they are not briefed individually on those cases. But I would have to see a specific example of a case and then
Sure.
go find out and get a response for you. I'm sorry to be, I just
No,
think
no,
that it's just an incredibly complicated, and we have to go up a misty mountain and find a long white bearded gentleman to be able to explain the dynamics of that 700-page memo.
absolutely. And we're all just trying to sort this out. I think, Alan, with respect to your suggestion that we need to make some reference to the Department of Justice, I think that the appropriate place perhaps to do that would be in the preamble rather than in this third recommendation.
I don't have any problem with where we're going to put it. I think the problem we have is what we're going to say.
Sure.
Because the Justice Department, main justice, litigates many cases, but by far the larger number is litigated at the U.S. Attorney level, which is spread out throughout the country. And my experience, both as an AUSA and on the other side, is that there's not a lot of communications with the agencies about what's being filed and what's not being filed. And, I think this is a really big substantive question as to what we're expecting to happen, because if we're putting the burden on the Justice Department and the U.S. Attorney's offices, we need to say that, explain how it's going to happen. Otherwise, and if we're expecting that people are going to be able to go to whatever agency it is, and let's only talk about the significant cases, and expect to find the relevant pleadings there when the relevant pleadings don't ever get to that agency, or many of them do not, then we're going to have people that are disappointed. So I think we really need to decide what the government is capable of doing, even within the subset of significant cases, because most of the cases are litigated by the Justice Department and not by the agencies themselves. And certainly in terms of completeness, the agency is not likely to have many of the pieces of paper, even today with electronic transmittal, and much easier to get back and forth than it used to be. So I think this is a really big substantive point that we have to get over before we can make a recommendation that will either have some teeth to it, or we have to concede that it's going to be very limited, and then we'll have to decide what we want to do. Thank you.
No, I take that point. On the one hand, this recommendation is framed in a very permissive, very discretionary, very agency, you decide what is best for you sort of a way. And I think that there's merit to that. But, it does seem that we need to have some sort of comment or framing with respect to expectations in the Department of Justice. I think that the preamble is probably the place to lay that out rather than in the recommendations themselves. But I don't know exactly what should be said either. I'm wondering, while we are continuing on, if somebody can take a stab again at coming up with something as a proposal for the preamble with respect to the Department of Justice, that we can then debate when we get to the preamble, if we ever get to the preamble.
Kristen Mass, what is it that the Justice Department is capable of doing, is prepared to do, wants to do? There's no point in us making a recommendation that the Justice Department should do something which we know from the beginning it's not prepared to do. If the facts of the matter are that the Justice Department is not prepared to do this for all the cases or all the significant cases it does it, then maybe we just have to say that and go on, and that something is better than nothing. I don't know. Mark, I saw Mark raise his hand. I can't see anybody else when they raise their hand. I don't know if they can see me or not.
Mark, please go ahead.
I appreciate the point that Alan was making, and I the significance of including something specifically directed at DOJ when you're talking about litigation is something that, as I mentioned earlier, is fairly obvious. The flip side of that is, as Kristen said, we've identified these recommendations are framed at a high level. They give agencies considerable discretion. The reason I think they are framed that way is precisely because agencies face all these different constraints and considerations that are largely unique to them. DOJ is not exempted from any of that. And so it strikes me, looking at these recommendations, that a lot of the carve-outs and exemptions or caveats that are already included within this provision that apply generally justify an agency doing exactly what some people are suggesting DOJ might do. If DOJ feels, for example, that it is imprudent to publish all of the litigation filings from the U.S. attorney's offices around the country because for organizational reasons, they're just too dispersed and it's too much work, I think a number of the considerations that we're looking at right now in recommendation 3 would very much allow DOJ to do exactly that, with or without a carve-out. That's not to say language in the preamble wouldn't be helpful, but I think the recommendations are designed to address this even without anything specifically directed at DOJ. That's solely my opinion, and again, I'm not a committee member, but take it for what it's worth.
I will make the observation. I think it was clear from our last meeting, and it's increasingly clear in this meeting too. I think we all recognize that perhaps somewhat unusually for an ACUS recommendation, this is not a recommendation where we are saying all agencies should do X, but rather this is sort of this is a recommendation in which we're saying some agencies are doing X and other agencies may want to consider doing X. And while we may not end up in a perfect world of, of all agencies having litigation web pages where everything is 100% transparent, half a loaf may be better than none.
May I, when you're ready, Kristen, may I just offer a comment and a question?
Yes, please go ahead, Matt.
Are we contemplating is there another meeting scheduled on this recommendation? And were we contemplating a vote on the entire recommendation today?
There is not yet another meeting scheduled, but increasingly it looks like there may have to be. Or
Well,
some version of that.
my only question, and maybe it's a question for Brady and or Kristen, is whether it would be worthwhile for the ACUS staff and Kristen, of course, if she has the time, to consult further with DOJ to find out exactly where we are. I think just as a matter of sort of interagency comedy and so forth, that DOJ should be very comfortable with this recommendation. But just in terms of the committee's own work, we really don't want to get in a position where we have a vote on something and DOJ is really not comfortable with it at the end of the day, and basically we just have a big mess at the plenary session. And so I think there might be some value, and I'd be interested in what Kristen thinks, and also Brady, about having some further discussions with the Department of Justice and those components of the Justice Department and those officials at the Justice Department that Brady thinks would be especially appropriate to consult with here, and so forth. So anyway, it's sort of a question and a comment.
I think it's fairly obvious that we're going to have a third meeting, unfortunately. It would have been nice to get through it today, but at the same time, they're just, this is proving to be a tricky one to get just right. So I think, especially given DOJ concerns, I think, and working that out, I think that a third meeting's warranted, and before we schedule the third meeting, we need to sort of sort this out to a certain degree with DOJ. Brady, does that sound sensible to you?
Yeah, I'm happy to go offline with you guys and try to figure out language and shoot the or deal with the main battle, and then we can the next meeting we can just shot by shooting.
Okay.
Kristen?
Mark, yes, please.
I have an idea in the back of my head for some language which I don't want to try to draft while we're having this meeting, which would set
Sure.
forth the realities of what the Justice Department can and can't do. And the main purpose of this is not to proscribe anything for anybody, but just to have somebody looking at the recommendation understand that it's going to be impossible to do everything we would like to do in terms of the ultimate goal, because we have a bifurcated situation in which the Justice Department actually handles most of the litigation for agencies, and they don't have the access to everything. And I just want to be sure that we're upfront and not suggesting that agencies or the department should do anything different, but B, at least making it clear what the limits of this recommendation are going to be. And I will try to draft something and send it to Mark, and then you can play with it and get back in touch with me or whatever you want to do and circulate it to everybody. As far as I'm concerned, it's nothing secret. It's a public record as far as I'm concerned.
No, that would be much appreciated, Alan, if you would take a stab at drafting something that we can then debate, and send it to Mark, and then that can be added to the discussion. We can go through it with Brady and the people at the Department of Justice, and then we can tee that up for our next meeting by having specific language to discuss and wordsmith.
And Kristen, you wouldn't have an objection if we, this is Drita Tanusi, if we touch base with our counterpart at DOJ, because
I would be absolutely delighted to have you do that, Drita.
Yeah, no, we are, most of the other agencies have DOJ litigating most of their litigation. We are exactly in the opposite scenario where we litigate most of the litigation. Okay.
I understand, and I welcome any consultation and or suggestions that you bring to bear in this regard.
And Drita, this is Brady. One tiny thing. If you want to bring me in on that call, if that's helpful for you, I'm happy to do that.
Sure thing.
Okay. A couple of smaller things. Well, I don't know if they're smaller or not on this. With respect to this what is now the third recommendation. So Alan had suggested at one point in his markup that we move item A concerning costs lower in the list so that we don't list the costs before we list the benefits. Do I hear any objection to moving the item A?
From my vantage point, this is Drita again. I think cost is like the biggest factor.
I'm not. I understand, and that's cost of that was a big issue that came out of our last meeting. However, to the extent that this is a recommendation that we're hoping some people follow, while acknowledging the costs, is there a problem with emphasizing the benefits? Can we agree on, can we at least kind of agree that we don't want to sabotage our own recommendation by fronting the fact that the costs might be a problem, and we could put the benefits before the costs as they are on the slide at present, or they were a second ago? They're still in there.
I think the costs are the elephant in the room.
Sure.
Might want to slow down just to get.
I'm sorry, whoever's speaking, I'm having problems hearing you. Okay. Alan, you were the one who proposed this in the first instance. Do you want to weigh in here? Alan?
Look, I agree that the cost of the elephant in the room, but if we're making a recommendation, we should put the things that are beneficial first and put the costs afterwards, because everybody knows about the costs. Look, agencies are going to do what they're going to do. I don't think it's worth spending. If there's a serious objection to it, then I just don't care. I just think it's wrong, but I don't care.
Shall we take a vote on this one too? Does anybody else want to weigh in on this particular question? I mean, at this point, I'm kind of hearing, I think, me and Alan on one position, and Trita and I think somebody else on the other side. Is there seriously a conflict here, or can we be happy with costs being item D? Okay, I'm not hearing anybody objecting at this point to leaving it with costs as item D, so let's go forward. Okay, so then the IRS proposed from the IRS draft, they added several additional items to this particular recommendation, specifically the risk of disclosure or wide dissemination of confidential or sensitive information of private litigants, the availability of the information on other public websites, the significance of the litigation to the agency's mission and purpose, the confusion that the materials may cause the public when the area is evolving rapidly, and the publication of the agency's litigation material without the private litigants' positions may give the public an unbalanced perspective. So, the private litigation concern here, or the private document concern is rising up again. I don't know, Mark, if we can get all of that up on the slide so that we can look at the proposed language.
And Kristen, with respect to the private litigants' position being publicized, I think in our case, we would certainly want to get the buy-in of the private litigant to include their materials.
Sure, I understand. I understand, especially with tax court materials, that often, despite best efforts, in the majority of cases, the between appendices and other materials, that social security numbers, minor children's names, all kinds of personal information ends up slipping through best efforts and ending up in the litigation file.
Kristen, really quickly, you cut out. Were you asking me to pull up the IRS's red line, or would you just like me to add it in?
Well, the IRS has proposed 5 different additions to this particular item that I think are worth our considering as items G through K.
Hold on for one moment, then I'll pull it up.
Yeah, and so, it seems to me that may be easier than trying to keep them in anybody's head. Okay, so G through K on your screen are the proposed additions. I would welcome thoughts or concerns with respect to these proposed additions. Or Drita, perhaps you could explain the IRS's thinking in proposing them, since you're involved in proposing them in the first instance.
Sure. So with respect to G, the risk of disclosure or wide dissemination of potentially confidential or sensitive information, I mean, that's kind of self-apparent. Tax is slightly different than everything else, although there might be other litigation with sensitive information. But here, because, disclosing confidential or sensitive information could cause to ID theft and fraud, that's what really concerns us. So, again, we have discretion in terms of what we put up there, as we've noted. But notwithstanding, I think, things do slip through. So that's what G covers. The second, or H, is the availability on other public websites. So one of the things that, one of the items that we would publish on this website are the opinions of the court And the tax court actually has a fairly friendly list of opinions that are searchable. I mean, it's not a Boolean search process, but they're searchable. So, so instead of actually creating the website, we would potentially make, link to the court's website if anybody's interested in looking at the most recent opinion. Now, they are not organized or stratified, but that would be, something that's available on another public website. I is, actually, this is the significance of the litigation. Again, trying to cull it down. This actually addresses the deliberative process privilege that we talked about earlier. J, so in some areas, the law is rapidly evolving. I can think of one area relating to penalties where you might confuse the public because they might be referring to what is on the public website, and because it may not be updated quickly enough, the law might have changed, and so you're actually serving to confuse the public, not help the public. And then the last one is, again, this notion of balance, because if we just put the government's position up there, taxpayers may be misled to think this is the position that everyone should take. It's not different than the frequently asked question issue that a lot of folks have, is when we put it up there, even though it's not binding on anyone, they think, well, the IRS has decided this, and so I have to follow it. So we would hate to mislead people. So having the opposition also reflected on the webpage makes more sense.
Questions, comments, concerns with respect to each of these 5 items? Barbara Silverstone, please go ahead.
Sure. So I want to agree very much with the recommendation about the risk of disclosure of wide dissemination of confidential or sensitive. Was that the one? The one about the the private litigants, right? That one. Again, with Social Security claimants, like with IRS litigants, there is so much private information, people's medical conditions, history, work attempts. There's a lot that even if the case name just went to initials, a lot could be figured out who that person is. And even, I know that everything is public, but it's harder to get if it's not right up on a web page. And so I really support that recommendation to keep things private on there.
Other thoughts and comments? Andy Vollmer.
So I had a couple of reactions reading through the list, and so I thought I'd just mention them. These are my reactions. The risk of disclosure of confidential or sensitive information is an extremely important one, and perhaps should go in this list in paragraph 2, because maybe there are agencies like the IRS or maybe Social Security Administration or something that have so much personal information in their court filings that it bears on large categories of court filings that should be excluded, or maybe even is so important that they don't want a website at all. So maybe that's a sufficient reason to keep it, but I just want to point out paragraph number 3 is all about safeguarding personal information and trade secrets and stuff. The next one, availability of information on other public websites. I thought one of the principal goals of this recommendation was to centralize a place for an interested member of the public to see all the cases relevant and all the important documents in a particular case at the agency's website. Because it is true for every one of the agencies that other public websites have all of the filings. So PACER Lexis, Westlaw, the courts all have their own, often have their own websites for court opinions. So I would just suggest that's not something we want to include in this list. The mission and purpose, the next one down, significance, it duplicates D up above. So I wasn't sure if it added, if it adds something, I don't get it. And the confusion that about materials, I wasn't sure I followed the confusion point. It strikes me that, again, that might be a case specific or even document specific problem that just should be within the agency's discretion not to post some document if it's going to be more confusing than helpful. And I didn't understand its pertinence to a general consideration, but I could be missing the boat on that. And I just want to fully support the last one. I have to say I'm not following the concerns about posting private litigants' filings on a selective basis, because I just don't see how you follow agencies' positions without, in many cases, getting the private filing. But again, I'm not sure it goes in this general list. So those are my reactions for you to consider.
So an alternative for some of these, these are things that we thought about and that might relate to us, and they might not make sense to other agencies, but perhaps some sort of catch-all and other factors that may be, unique to the agency, something of that nature.
Sorry, the list disappeared from the screen. I don't feel especially strongly about any of these. I will say that, at least with respect to the confusion that the materials may cause the public in the area is evolving rapidly. I have two minds, because the last thing we want to do is cause confusion for the public. And yet at the same time, there's also an extent to which when, precisely the kind of documents you'd want to have available are when something is a hot issue and you want to know what the agency's thinking about it, right? Mark, do you have any suggestions about from your looking at this, and I recognize you are not a voting committee member, but can you give us some insights? You put together the original list about how these, to the extent some of these overlap with other items on the list, or whether catch-all language could capture all of these.
Sure. My only thought, and this is actually what prompted me to inadvertently scroll up to the initial language and recommendation 2, is that something along the lines of agencies should consider, among other things, the following factors might simply do the trick without having to do a lot. It might indicate that the list is non-exhaustive and that agencies can consider whatever other factors they deem appropriate. But I think that there are always issues with, when you enumerate so many things, people start to wonder, I think, naturally, whether the failure to enumerate something means it's not included within the list of permissible considerations. And so in some ways, Drita's suggestion about the catch-all language makes a good deal more sense to me than having a list that is however many items long at this point.
Sure. How can you go back up to that, to the previous page? How about if instead of agencies should consider the following factors, how about changing to among the factors that agencies should consider are the following? That way it's, and you're changing the IRS's version, I think, but that way that way at least we make clear that these are not the only factors, that this is not an exclusive list. And then going back to the IRS's document, sorry, Mark. If we go back and look at their list, I mean, Drita, does that help with respect to catch-all language?
It helps somewhat, but I'm pretty sure that there might be some who say, like Mark indicated, that if you bothered to list,
Sure.
5 items, why didn't you put in a catch-all, or why didn't you?
Right. So looking at the list that you've got, I mean, Andy makes a good point about which item was it? Sorry, I'm going to look at my own document here. He makes a good point about your item I, the significance of the litigation to the agency's mission and purpose, seeming somewhat duplicative to item D.
Yeah.
So can we delete item I?
Yes.
Okay.
And I agree with the availability of the information on other websites.
You're okay with deleting that too?
Yeah, I feel really strongly about the sensitive information, the dissemination of sensitive information. And the other part of this, so especially our litigants, if they know that we're going to publish all of this on an easily Google searchable site, and all of a sudden their information may be aired in the public, it might disincentivize them to litigate. Just throwing that out there.
No, I take the point, and I, for one, don't have a problem with including your item G. I mean, I think at various places in this recommendation, if I recall correctly, although I haven't identified them readily at the immediate moment, I think that there is emphasis on privacy. But at the same time, I understand the point and I don't disagree with you. So I have no problem, to the extent that we have a list of 6 items, I'm not sure that 7 is going to break the bank.
Right.
Right. Go ahead.
And I'll litigate against myself. So J, the confusion about evolving areas of the law, you're right. That's something we can control. If we see that there are lots of opinions coming out in an area, we'll just hold off until the court has spoken, or at the circuit level.
Right. I mean, I think that falls within the discretionary point. I'm going to say, since we're going to end up having a third meeting, I'm going to say let's keep item H for now. What is now item H? The publication of the agency's litigation material without the private litigants' positions may give the public an unbalanced perspective. I recognize that contradicts what I said earlier about I felt that we had settled this in the last meeting, but given Andy's comments as well as Paul's earlier, and we're going to have a third meeting, let's leave it in there and then we can debate it again. That seems the right way to go about doing this. Let's see if we can get at least one more of these knocked out. If that's all with this, with what is, Mark, I will just trust you to be able to move those over appropriately. There we go. Can we move on to item 4? Okay, Brady's got a comment for 2H. Please go ahead, Brady.
I sent that off, Kristen. I'm happy to wait and table the issue. I just do not want to have the impression that there was a consensus that private filings should not.
No, I think it is quite clear now that what I regarded as a consensus from the last meeting is anything but a consensus. So we're simply going to have to resolve that at our next meeting, I think, and we will make that a point for continued discussion. Let's see. Looking at the next item on the list, I actually don't see any proposed changes to that one, at least not in my notes. If anyone has any proposed changes to what is now item 4 on the screen, please let me know. But in the meantime, let's move on to item 5. What is item 5 on the screen?
Actually, sorry,
Go
Kristen.
ahead, please read it.
We had included the concept that if the private litigant objected to their information being disclosed, that we would refrain from publishing it.
I apologize. I'm getting my numbers and my drafts in front of me confused. So thank you, Drita, for calling that to my attention. So yes, the IRS had proposed adding at the end of this item 4, the agency should refrain from publishing materials where private litigants object to their information being disclosed. I would welcome thoughts, comments, or concerns about this proposed additional sentence. Please, Alan Morrison, go ahead.
This seems to be counter to the whole recommendation and to basic notions of openness in government. If there are exemptions under FOIA, or if documents shouldn't have been published to begin with, that's okay, and it can be withheld. But suppose a litigant is getting a very good deal in a particular tax case, to take an example, and the litigant says, I don't want the government has conceded this liability. I don't want anybody else to know about it because my competitors might get an advantage or it'd be bad publicity for me. I just think that the agency should refrain from publishing materials. I mean, I'm perfectly okay with identifying trade secrets or personal identifying information, but the notion that a private party has an ability to veto the government from making something more readily available when it's already published, because that's the proposition to begin with, I'm quite offended by that, and I would strongly oppose that sentence.
Brady Tonsing.
Yeah, I agree. It runs counter to the whole purpose of this proposal. I mean, making information public. So then if an agency has already posted something, could a private litigant come in and demand they take it down? Just think it opens a Pandora's box of problems.
I will concede this is my reaction to this particular sentence as well, that it's contrary to the spirit of this entire recommendation. And moreover, that allowing private litigants, I mean, outside of the Privacy Act, where we do have such a thing as reverse FOIA litigation, we've got other statutes on the books that protect, truly sensitive information for many people. Absent that, the idea of giving a private party a veto over what publicly filed documents an agency can put on its website strikes me as problematic. Drita, do you have a reaction to that?
My reaction is, I just don't want to have the litigant be caught flat-footed that all of a sudden all of their pleadings are now in a public website where they weren't before. So maybe a notion of notice, maybe not a veto, but a notice.
So in other words, an agency would be obligated to provide notice to every private litigant, hey, we're going to put your otherwise publicly filed documents on our webpage?
And maybe it's a generic notice, on their website.
A generic notice at the top of the website. Mark?
Yeah, I think I won't presume to speak for agencies about the generic notice point, but it does seem like part of the confusion here might stem from maybe the ambiguity in the term their information. The recommendation itself already exempts PII, confidential information like trade secrets, for example, that litigants have a potentially protectable interest in. Once you make something public, historically, it does seem a bit odd to me that you would suddenly regain control of it for some limited purpose like this. I'm not sure I can think of another context where that happens, but that's just an observation.
Kristen, to be clear, we're talking about agency materials, not the private litigants' materials, and so that's why the there is maybe somewhat confusing. But the notion that a private litigant can tell the agency what not to make public after it's already been public and it's not trade secret or personal information strikes me as being just wrong.
All right.
All right, Judy, you're okay with giving up this sentence?
Yeah, withdrawn.
Okay, we'll delete that sentence. Okay, so then moving on to the next recommendation, what is currently on the slide is item 5. Let's see. So what I have here is a suggestion from Alan that everything after the M dash, or not everything after the M dash, but the portion of the sentence after the M dash in the first sentence, what this recommendation refers to as an agency litigation webpage, is sort of redundant and unnecessary. Mark, do you have a thought as the drafter as to why this clause after the M dash in here?
I think someone mentioned earlier, it may even have been Alan, I forget, that it's a bit odd to have, or that the preference is to have definition terms defined within the recommendation, not just within the preamble. And this is a version of that, I think. It makes clear what we mean subsequently in the recommendation. Just looking down, we start talking about agency litigation web pages. This is, I think, the first use of the term in the recommendations themselves. And so for that reason, defining the term seemed useful.
Let's see. Well, except, I mean, we essentially define agency litigation materials in the first recommendation, at least.
So agency litigation materials are distinct from agency litigation web pages. I agree with you that we do define that in the first recommendation.
Do you think anyone would be confused without this definition?
That's the other issue.
I don't think so.
I'm inclined to agree. Does anybody have an objection to deleting this clause? Okay, so deleted.
And if I would say, if we need to clarify it in any respect, it can be done in the preamble. This is not exactly an operative definition. It's
right.
A terminology.
Okay. Any objections to then moving on to what is now item 6?
I think Alan made a note about the footnotes, whether you want to address that.
Yes, that's right. Alan, somebody made a suggestion about the footnote at least.
That's a felony, I think, under our rules, right, Matt? It's a felony to include a footnote in a recommendation.
Yeah, I think we just continue to exclude, not to do that out of respect for Paul Verkyle's preferences. I don't know if it's but somebody will object to it at the plenary session. I actually don't have a strong opinion on the matter.
I tend to, surely anything that's in a footnote can be explained in the preamble. Is that acceptable to people? I tend to agree that footnotes and recommendations are probably not the most advisable thing ever. Again, it's not a life or death battle for me, but okay. Let's go on then to the next item. So Alan had proposed an adjustment to the first sentence, and then there was a friendly amendment from Ron Levin that Alan suggested. So there is a proposal to change the first sentence of this recommendation, largely for clarity, to read that agencies that post litigation materials on their websites should make sure that website users can easily locate those materials. I don't think it really changes the meaning of the sentence too much, so much as it just makes it clearer and, a little bit more grammatical, perhaps. Does anyone have an objection to that amendment? Seeing none, there is a proposal to change in the second sentence of this one, to change might to can. Does anyone have an objection to that change? Alan, I'm not sure what the thinking behind that change was. I don't know if you want to, state it for the good of the order, or if we can just move on.
Move on. I think it's clearer, but I don't.
Okay, we'll just leave it as can. So then the suggestion was made that after item A, that we change the and to an and/or. My recollection is that it is at least one plenary session that I have attended, there were substantial objections from the floor about the use of and/or. I don't really feel strongly about it myself.
Withdrawn.
Withdrawn. Okay. Those are all the edits I see to this item 6. Does anyone have any additional edits to propose? Okay, moving on to item 7. I have a recommendation to replace should consider with should, which would change that to should post links, I think.
Yes.
Which is a more forceful statement, one that I don't think is necessarily incorrect. Do people have comments, concerns, or suggestions there?
I propose the change because it only applies when the agency collects it in a single litigation web page for all of their units. And it seems to me when they do that, we can safely say they should post a link on their website to the other pages. It's hardly a radical suggestion, rather than.
No, I don't think it's especially radical either, but I'm often surprised. And then you would also propose striking the last clause rather than maintaining their own litigation web pages.
It's unnecessary.
Any objections to that amendment? Hearing none. Let's see. And then, bear with me for a second here. I'm making sure. I don't see any other proposed changes to that recommendation. So can we move on to number 8? Seeing none, moving on to number 8. We have the proposal we have a few proposals here. One from the IRS, a proposal that at the start of this recommendation, we add a sentence that says agencies and their components should have maximum flexibility in organizing their materials, or excuse me, organizing materials. Drita, do you want to comment on the thought behind, I mean, it's really self-explanatory, but the thought behind why we need to add this sentence?
So I think, if cost being one of the most significant factors that agencies will have and will consider, you can minimize the cost factor by just publishing, documents as they come up, as opposed to organizing the documents by case or by topic or by subunit. You know, we in the Chief Counsel's office have different subunits. So I think it really shouldn't be entirely up to the agency to figure out how it sorts. And the fact that EPA does it one way should not in any way dictate how the IRS does it.
Thoughts or comments? Objections to including this sentence? Hearing none. The next suggestion that I have is in the very next sentence, agency litigation web pages should group together materials from the same and related cases. It does seem to me that it seems to me that the sentence that the IRS proposed and this next sentence actually seem inconsistent with one another. On the one hand, so I guess that means we need to have a more extensive discussion which way it should go.
Actually, Kristen,
you can't tell agencies that they should group their materials from the same cases while simultaneously saying that they should have maximum flexibility so that they don't have to group together cases.
Right, but Kristen, you will note that we suggested that the next sentence should read, should consider grouping, should, and then we continue.
Yes, I missed that edit. Thank you, Drita.
Yeah, so that would then make it consistent.
I'm
So
okay
your
with
proposal
that.
is that agencies should just be able to throw everything up on the website in a higgledy-piggledy order?
I'm okay with adding that sentence and the suggestion that was just made should consider, but let's add related cases together because it's a concept that's fairly common and we ought to support that, I think.
I think that's sensible too. The same and related cases is the proposal in that regard. I mean, I see some sensibility. The whole recommendation is about flexibility. So I don't see any harm in saying both. Mark, I see you've got a comment.
Sure. To some extent, it's true that the recommendation is about maximum flexibility, but maximum flexibility would be no recommendation whatsoever. Agencies would be free to do whatever they want. I think the notion, to some extent, this is prescriptive. If the argument is, well, we should just post documents on some random web page as they come in, regardless of case, that seems to me counterproductive to the purpose of the recommendation, which, as someone else has mentioned during this meeting, is to consolidate materials in a way that makes them easy to find and digest on a matter-by-matter basis. So I recognize the need for agency flexibility, and flexibility is important. I think that there is some good sense in being careful not to go too far away from the prescriptive nature of the report and probably the purpose of the recommendations.
So my response to that, Mark, is if the ask becomes too costly and burdensome for the agency, then the option will be not to do it at all. And so I think it is a balance between burden, cost, and what's possible, right? So that's why maximum flexibility is a concept I wanted to include.
I think, I would propose dropping the word maximum from the sentence, but at the same time, I like the idea of mentioning flexibility, leaving aside the grouping issue. I can anticipate that with different agency websites, that how you group together materials, or I think some grouping should be done, and we specifically suggest grouping, and yet at the same time, there may be how you group things together may involve some judgment and some different considerations in different agencies. So I don't think that we necessarily undermine Our recommendation that agencies consider grouping together materials from the same and related cases simply by saying they should also have flexibility in how they do it. Especially since we then go on and get even more specific and say that they might, for example, provide a separate docket page for each case. You know, I know, Drita, you've got they might consider providing a separate docket page. Does anyone have an objection to consider providing instead of provide in that second sentence? Okay. Where is that used? Drita, are you okay with changing components to component units, which is the same phrase, even though we're going to move the footnote is describing component units?
Oh, yes, absolutely.
Okay, let's change that to component units. Let's see, are there other proposed changes to this one? Those are all the changes that I see proposed to this one. Brady, you've got a comment. Please go ahead.
Yeah, I mean, I don't mind getting rid of maximum, but can we add something else in there instead, like substantial or significant? It's not going to maximum, it's a happy medium.
How about substantial?
I like it.
I'm fine with substantial. Thank you, Brady. Does anybody have any other suggestions with respect to this recommendation number 8? Okay, moving on to recommendation number 9. I'm not seeing any proposed amendments to that one.
None.
So we've at least made it through the recommendations. Okay, which leaves us then with the preamble. Now there are some various recommended changes to the preamble. I'm not sure we're going to get through them all in 15 minutes. However, I would like to at least try and see if we can preview some of them. If for no other reason than it may help us going forward as we move into the third meeting. So bear with us for a moment while we get set up here. Okay, Mark, we're going to leave the bubble comment, and I think during the break between the two meetings, we can find a place for a reference to recommendation 2017-1. I don't think anybody objected to a reference to recommendation 2017-1, so we'll just find a place to put that, and then hopefully that will suffice in that regard. So we do have.
Kristen, I made a couple of suggestions, and I'm willing to leave it to you and the staff to
Okay.
accept them or not accept them. And there'll be some other changes as well, particularly regarding the DOJ. And I, given the lateness of the hour, maybe it doesn't make sense to try to spend a lot of time on editing preambles at this time, because the staff may want to make some other changes along the way as we've shaped the recommendation. And
fair point. I'm going to make one or two observations here based on my recollections from what we have just done over the last couple of hours. One is we need to adjust the use of the word consent decrees to reflect the change that we made in the first recommendation. And that is on line 3 and also then on line 27. I believe it's line 27. I would call everyone's attention to, so even though Alan's recommendations are relatively minor and we can probably deal with them, moving forward, the IRS did propose several changes to the especially the start of the preamble of this recommendation. Mark, I know you just closed the IRS's recommendations, or the IRS's edits.
All right, hold on.
Kristen, it's Andy Vollmer. Could I make a suggestion about that?
By all means, please.
Well, my suggestion is along the lines of Alan Morrison's, which is I would propose that you and Mark and the staff consider these suggestions and put something in a new draft. But
Yeah.
my reaction is that there's valid and meritorious points, but they don't go in the first paragraph because they seem to detract from the thrust and overall goals of the recommendation as a whole when they're in the opening paragraph. So that's why I suggest if you agree with any of what I just said, maybe you and Mark can think about the points and add them at a more appropriate spot.
Sure. Dorita, do
Sure.
you have an objection
I have no objection.
to our reflecting some of these concerns later in the preamble?
I have no objection. I was trying to get to the thrust of what we were doing. And,
sure.
You know, I'm not entirely clear. Are we trying to give the public everything? Or are we trying to give the public information that will help them make decisions about, you know, how to proceed?
Sure. You know, and there seems to be at least some amount of debate over that. You know, so how about we take this into account and then we can, you know, with only 10 minutes left, I take the point, and we're all tired at this point. It's been a long meeting. So we'll tinker with the preamble to reflect, you know, these concerns and changes from the, you know, that we've made to the recommendations, and then circulate a new draft, and we'll schedule a third meeting when after we've had an opportunity to confer with DOJ.
Sounds good.
Wonderful. Matt, is there any problem with our adjourning 10 minutes early?
Absolutely not.
I think we're going to adjourn 10 minutes early. I'm tired. I'm sure you all are too. But I think we've made a lot of progress today. So I very much want to, I very much appreciate and want to thank everybody for the attention that they have paid to this recommendation and to all the excellent suggestions that people have made, as well as the spirit of cooperation as we have negotiated our way through a few different disputes. So thank you, everybody, for that. I think this has been a very productive meeting, and I, for one, am highly appreciative, and I'm sure everyone at ACUS is as well. With no further ado, you know,
Kristen, can I just my only further ado is to echo what you have to say, but also I think on behalf of everyone to thank you for so adroitly chairing this committee meeting, and also, and I shouldn't forget Mark too, who's really done an exceptional job, not only he's serving a dual role here, not only as the staff counsel here, but also as the in-house consultant, and that's not easy to do. So thank you, Mark.
Indeed. Thank you, Mark, very much. We wouldn't be here without you on this project.
I don't know whether that's a good thing or a bad thing, but yeah.
In any event, thank you, everybody. You know, have a good evening, and I'll look forward to seeing you at our next meeting. Take care.
Thank you.